This podcast is brought to you by Customplan Financial Advisors, Inc., an independent insurance managing general agency in Canada. Financialpodcast.ca was developed with one goal in mind: to educate Canadians on important topics that affect their financial well-being and make it readily available to all. We welcome you to plug in and learn with us. If you have questions, please email us at contact@financialpodcast.ca.
Hello and welcome to the Financial Podcast. My name is Gary Poyer. The Financial Podcast is brought to you by Customplan Financial Advisors, an award-winning managing general agency that provides exceptional support and resources to the independent financial advisor. Please visit customplanfinancial.com to see all of the resources that are available to you as an independent financial advisor. In today's podcast, we're going to return to a key component of financial planning, that being estate planning. But rather than looking at the usual cases when it comes to estate planning, we're going to take a look at some special situations. I'm happy to say that we have with us today Jonathan Ng from law firm Underwood Gilholme in Calgary. Now, if Jonathan's name sounds familiar, it is because Jonathan was with us back in March when we had a two-part podcast on wills. So, Jonathan, welcome back.
Thanks, Gary.
Jonathan, why don't you take a few minutes and tell us about yourself and your law firm?
Sure. I work exclusively in the area of estate planning and estate administration. So practically speaking, I help individuals prepare wills, enduring powers of attorney, personal directives, and trusts. I also help executors with the administration of estates, and I help attorneys in their role as power of attorney. Our group, Underwood Gilholme Estate Lawyers, is a boutique law firm in Calgary dedicated to this area of law only. And we also assist with trusteeship and guardianship matters and estate litigation when estates go awry.
Okay, excellent. Well, it sounds like you cover a pretty broad area of estate planning. So it sounds like you're the perfect guest to have on our podcast today. Maybe we'll start with something easy, just for our audience sake. But Jonathan, what is estate planning?
Sure. It's a broad term that generally refers to the process of managing wealth in anticipation for death or mental incapacity. So managing your property, investments, your stuff, right? Yeah. With a view to knowing that one day we'll pass away or potentially not be able to make decisions on our own. It's a broad term. It's a broad area that involves many professionals, including the many advisors that are listening today. So financial and insurance advisors, lawyers play a big role in estate planning, and even healthcare professionals. As a lawyer, our main role is to prepare legal documents.
Okay. And what are some of the legal documents associated with estate planning?
Well, the centerpiece certainly is the will, right? The will sets out the distribution of wealth upon death. It also serves to appoint an executor to oversee the estate administration, guardians for minor children, if the person who's writing a will has minor children. Mm-hmm. And a will also sets out trust terms for any beneficiaries who receive something under the will that need special conditions. I guess we'll expand on that a little later. Now, accompanying the will are two common documents. Here in Alberta, they're known as the enduring power of attorney and personal directive. These two documents operate while a person is still alive, usually at a time when they're mentally incapable of making decisions on their own. So that first document, the enduring power of attorney, appoints someone to manage property and finances, while the personal directive appoints someone to manage personal and healthcare decisions. So again, the will, enduring power of attorney, and personal directive, these three documents I like to call the trinity of estate planning. There's a whole host of other estate planning documents out there, usually associated with special tax planning, succession of real estate, like a family cabin. I talk about that today. Mm-hmm. And succession of family businesses. These are rare, but we do see these occasionally.
Okay. All right. So estate planning can be either relatively simple or quite complicated, depending on the situation. Okay.
Indeed.
How would you describe the traditional family unit?
Sure. I would describe the traditional family unit as married, and by married I mean the real deal. Walk down the aisle, sign the certificate, married, with children together, only with the person that you walk down the aisle with.
Okay.
Right. And I think for a lot of families, sure, that describes their situation, but very easy to have a non-traditional family. It's very easy to fall off that script. So common things that we see that's untraditional, so to speak, would be not in a married relationship, a common law spouse, whatever that means. So we'll find out a little later. Common law, children from a previous or other relationship, or generally speaking, a second marriage or a subsequent common law relationship. All of these circumstances give rise to, I guess, what we would call a non-traditional family unit.
Okay. Yeah. I mean, the family unit, or what is considered the family unit, has certainly changed over the years from, probably even 50 years ago. It's quite different. So let's take a look at a number of different scenarios and see how the estate planning documentation might change. So let's begin with, let's say you have a young married couple with a young family. What are some of the issues that you as a lawyer would advise your clients on in that kind of a scenario? So young family, young married couple.
Okay. And just to clarify, this is that traditional family we talked about earlier.
Yeah.
Okay. And to narrow things further, we'll say that the children are under the age of 18, or certainly at an age where dumping a pile of money on them might not be a good idea. So maybe early 20s even.
Yeah. Okay.
For some, all the way to 30. I don't know. Every family's a little different. Okay, so that's our traditional unit. If you and our listeners will indulge me, I want to run through something known as obligations. So before we get into the considerations here, I think it's very important that we set out what obligations do we have to family members, and I'll give some context, Gary.
Okay.
I always like to start here. When we're talking about planning a will, we should always recognize that people have something called testamentary freedom, and this we see this across the country. Testamentary freedom means the ability to give our stuff to whomever we want through our will. And that is something that we celebrate in Canada. We have this thing called testamentary freedom. But unfortunately, like many freedoms, there's fine print. Freedom is not unencumbered in this country. You gotta. There are conditions, so to speak. And the one condition, there's many, but one of the conditions I want to raise firstly that applies very much to your question is our obligation to provide for our dependent family members. Obligation to provide for dependent family members. So on one hand, we can give our stuff to whomever we want, but on the other hand, we are obligated to provide for our dependent family members. Okay, so so when we have a traditional family unit, maybe I'll speak speak personally. I'm in a traditional family. I'm married to my wife, and we have 2 young children together. So my obligation to my dependent family members sounds like this. Well, first of all, who are my dependent family members? A spouse is a dependent family member, including a common law. So I have an obligation to provide for my wife, and a dependent family member. One of the categories of dependent family member is a minor child, and we have 2. So I have an obligation to provide for them. So when to answer your question, what are my issues? What am I considering for my estate plan? Should I say I give to my wife and also give to my children? What is it, like 50-50, like half to my wife and then 25% each to my kids? In theory, yes, that would be providing for my dependent family members. And that's a way I would express my testamentary freedom. But because we are a traditional family, my wife, my children are also my wife's children, I give everything to my wife. So I have a very traditional will. I give everything to my wife if I pass away. And in doing that, I fulfill my obligation to my spouse and indirectly provide maintenance or maintain my dependent family member children, who are my wife's children. So to answer the question broadly speaking, the considerations here are who are our dependent family members, and by giving to our spouses in a traditional family, we are taking care of both our spouse and our children. This is all going to come in together a little later. It probably was a little bit too much for our viewers to just jump into this, but seeing where this conversation is going to be going, I think it's important that we review obligations. So other things to consider is how we give to our children. So I'll take it to another level. If my wife survives me, I give everything to my wife. That fulfills my obligations. And on a moral level, that feels right. She's the adult as opposed to our kids. She's the right person to have all the wealth.
Right.
Okay? And on that note, it's common to appoint your spouse, in my case, appoint my wife as my executor. She may as well do the work. It's in her interest to do a good job, so she should be the executor of my estate.
Right.
The next consideration for a traditional family, a young married couple, would be to consider what happens if both partners pass away at the same time. Very tragic. This is orphaning our children. This is our worst nightmare for young families. And in that situation, the common considerations are let's start with giving. Who is dependent on us? Well, our minor children. So we commonly express this in the will as divide our estate or divide my estate equally among my children. Okay. So we normally split it right down the middle for a couple kids. I know some days, depending on how rough those kids were at breakfast time, we don't want to split it right down the middle, but my suggestion to everyone is split it evenly. Okay. The kids. We'll write the will with an unbalanced distribution later in life, but for now, equally among the children. The big consideration in this scenario is less the giving. The giving is clear. We have an obligation to provide for our dependent children. Give it all to your kids and divide it equally. That's my advice across the board here. But the big consideration now is a three-part consideration. Who is going to make this all happen? Who's going to get this wealth to the children? Who's going to take care of the children? Who's going to manage the wealth for the children? Three roles I always like to identify for young families. Executor, guardian, trustee. Executor, guardian, trustee. The executor's job is to essentially turn this estate into cash, turn all of these bank accounts, insurance products, registered plan proceeds, real estate, turn it into cash, pay any final income taxes, and get this estate down to cash. And on average in Canada, that takes about a year and a half. And I know we talked quite a lot about this in a previous conversation, the role of executor. So executor, who you choose to do that, who you entrust to do that for your children. Next is guardian, who is going to be a parent to these children until they turn 18. And finally, trustee, the person who holds each share of the wealth that the executor worked so hard to create and keep that money safe for those children until they reach an age of choosing, of your choosing in particular, the person who writes the will. So again, I always like to tell married couples, hey, we don't have a lot of options with giving. We should give everything to our kids. But what makes your will yours, what makes your will customized to your family is who you choose as executor, guardian, and trustee.
Right. Yeah. Let me ask you a question. So let's say that there's a tragedy. Both parents are killed in a car accident. So then you have the executor, and the trustee and the guardian set up. What about a will for the children in that situation then? Does that make sense for the kids to have a will? Or what would happen to them or their estate should something happen to the kids?
Great question. So we always start with who owns the wealth, because it's that person's will determines how that person's wealth is managed. So if we're dealing with, say my family right now, where our children are 5 and 2, our kids really don't have much wealth, so to speak, that it was such that they would need their own will, right? Everything in our household is either owned by myself, my wife, or jointly between my wife and myself. So all of our wealth, our estate, would be administered by our wills. So not a concern. But let's change the facts. What if we're dealing with teenagers, older teenagers, and maybe they own their car, right? They have bank accounts of their own. Well, it is their will, so to speak, that determines how their wealth, albeit modest, is administered. Now, unfortunately, in Alberta, in order to have a will, one must be 18 or over, unless there is special permission from the court that minor person can write a will, which is very rare. I've seen it once in my practice. So I guess so just reviewing again, I think it's important to note that you sort of follow where the money is. Who owns it? And does that person have a will? If that person does not have a will, namely like a person who's under the age of 18, there's sort of a government formula, right? A formula set out in our provincial laws here that say who receives that child's wealth by default because they don't have a will. Quickly speaking, it goes up to parents, failing parents. It goes to the brothers and sisters, nieces, nephews, then grandparents, aunts, uncles. It sort of follows a family tree.
Right.
So when we have young people, let's just keep it simple. If we have someone that's, say, 21 years old and they're doing great, maybe they have a first job, they're slowly building their wealth, certainly worth considering writing a will. If they want to take a pass on the provincial formula and decide to give their wealth to charity or to a partner or to a friend. A quick footnote: a minor child can write a will in Alberta if they have permission from the court. Very rare. We see this commonly in a couple scenarios. Maybe if that child was the beneficiary of an inheritance and they have quite a lot of wealth, more than the average 15-year-old kid, which is a case that I saw, where he received an inheritance from his mother, who was a single mom. On occasion, we also see young celebrities who have quite a lot of wealth and they're under the age of 18. Very rare. Not my usual clientele, but certainly something that would be very interesting. And then another area I did see when I was fresh out of law school, sometimes young people have a significant amount of wealth because due to a legal settlement. In this case, someone who was in a car accident and suddenly this child has come into money because of a legal settlement.
Okay. All right. Let's move on a little bit. Let's say that that young married couple with a young family, marriage breaks down and they get divorced. So in a situation where you have a divorced set of parents, what are the obligations? Well, first of all, how does that change the will? Because they each had a will, but now should they go to the lawyer and rewrite their will? Or are there additional obligations for the father? For instance, let's say that he has to pay alimony. What other situation or obligations does he have in that situation?
Sure thing. And I'm glad that you went to obligations, because that's really going to drive what these two now separated spouses have to consider, right? Who do I owe an obligation to? Because on the face of it, they certainly don't want to owe an obligation to their ex anymore. For moral reasons, they don't want to do that. For personal reasons, they don't want to do that. But note, when a separation is new, when a separation is fresh, so to speak, so before the divorce takes place, and maybe before they've sorted out the division, we're talking about they've tried very hard on a personal level to make this relationship work, but they've decided to part ways, and maybe one partner's moved into a new home. This is very fresh. No one's hired a lawyer yet. No one has cut bank accounts yet. They've made the personal decision to separate homes. Let's go there first.
Okay.
Do note that will is still their will. That will that says I give everything to my wife and I choose my wife as executor, still the case. If I drop dead right after that separation, that's the will that's going to run. So this is a good reminder to the listeners or the advisors that if they're talking to someone, or if they are someone who is freshly separated, that old will that probably is offensive to you, by the way it's written, is still your will.
All right.
Okay? It's still your will. So that's going to light a fire under you to write a new will.
Yeah.
Obligations are interesting, right? Of course, let's do our inventory here. Do they still have an obligation to their minor children? Absolutely. Yeah. Do they still have an obligation to their freshly separated spouse? Arguably, yes. They have yet to separate their wealth, right? Which is often done through a legal proceeding, right? Commonly known as divorce. They still have dependency on each other. They might have their joint bank accounts still. This is very fresh. Their obligation, maybe not from a legal standpoint, but certainly from a practical standpoint, is still very tied together. So tough. It's a tough will to write, because on the one hand, I have a legal obligation to my spouse, but I also want her to get nothing. So how do I satisfy this? What I commonly do essentially in a situation like that, if I'm working with someone that's freshly separated but haven't gone through the matrimonial division, the divorce stuff yet, is let's write a will that gives everything to your kids. Let's shore up the wish in your heart, because that's probably what you want. You want to give everything to your kids. But the reality is your wealth is still entangled with your ex.
Right.
And that's not my area of law, but I would make sure that they're working on separating their wealth so that they actually have something that they can send down to their kids and make that will practically functional. I know this is not a discussion about matrimonial property and family property and divorce, but this is certainly something that certainly could be a topic for a future show.
Yeah.
I want to fast forward though. If I meet someone who says to me, I am divorced, right? Let's say I've gone through that whole exercise. All my stuff is my stuff now. Her stuff is her stuff now. We went through a bumpy patch of lawyers bickering, but we got it. Mine stuff is mine, but we still share our kids. What are the considerations here, right? Yeah. From a will writing standpoint. Well, the first thing I might ask that individual, say this client, say it's my client, I'll say to her, well, do you have an old will? Oh yeah, I have an old will. It says I appoint my husband, who's now an ex-husband, as executor, and I give my estate to my ex-husband. So this is some interesting trivia, but not trivial. How about that? Some interesting information here. So if that lady was to pass away with an ex-husband, and by ex-husband, I define that by someone that she's divorced from, we are to interpret her will, the distribution of her estate, as if that man is dead. So to the delight of many people who are divorced, we interpret your old wills as if your ex is dead. And that makes a lot of sense that because, that relationship is over and divorce has served, and at least in the province of Alberta, note that it's different across the country, but in the province of Alberta, we read that lady's will as if her husband is dead. And that's good, because normally the plan B kicks in and the will goes on to read, divide my estate equally among my children. So there we go. That will still might be satisfactory to her.
Yeah.
He is still the executor, though. I guess what I'm getting at is she should be writing a new will.
Yeah. Yeah.
That makes sure that her obligations, which are now solely to her children, are fully satisfied. She's choosing an executor, a guardian, a trustee that now match her wishes as a single mom.
Right. So when you have a couple that divorce and one goes to their lawyer and rewrites his will, for instance, does he have an obligation to let his ex-wife know that he's written a new will?
Oh, great question, Gary. I don't get that one very often. And it's a thorny one. You're going to get a good lawyerly yes and no answer to this one. If he goes to the lawyer who historically prepared his will and his now separated wife's will. So let's say, back when the relationship was great, 10 years ago, they went to go see me to prepare their wills. Mm-hmm. And I see this all the time. And then he comes to me and says, John, it's been a few years. Just to let you know, me and Valerie are divorced now, and I'd like to write a new will. I have to stop immediately. I have a legal obligation to him and Valerie to say, I want to work with you, Ed. But because I have a joint relationship with you and Valerie, even though I haven't talked to you in 10 years, I need to get Valerie's consent that you're writing a new will. And now Valerie is aware that he's writing a new will. That's right. That's just part of my legal obligation. When I work with a couple, we have something called a joint retainer. Everything that we share with each other. Any work I do, I have to do for both of them or with the knowledge of the other. That's the nature of the relationship I have with a married couple. So when I have a couple or an individual who comes to me and says, oh, you worked with us as the married couple, now we're separated, I have to get the consent of the other. But let's just change the facts. Let's say this gentleman comes to me, never met him before, never wrote, let alone wrote his will or his ex-wife's will for that matter. And he says, I want to write a new will. He has no obligation. I have no obligation to certainly tell this stranger to me, his ex, that I'm writing a will for this man. His obligation to tell her that he's written a new will is zero. He doesn't have to tell her what he's doing. He can do whatever he wants. So again, this is a bit of a fine issue, but do note that if you have a relationship with a lawyer as a married couple, that lawyer is obligated to work with you too as a married couple only, or unless the couple consent to it and say, no problem. Open 2 files. Valerie has a file, Ed has a file, and sometimes I'll work with them separately moving forward, which is nice because I have a history with them and I want to help them just as individuals.
Okay, well, that makes sense. Okay, so moving on to the next scenario. Let's say that the the ex-wife remarries, and the new husband comes into the family unit. How does that change the scenario? So the wife and the new husband are going to make a new will, right? But how does that also impact the ex-husband? Or does it?
Yeah, absolutely. So, and just to review, so we have previously a single mother who has, to be specific, let's say she still has minor children from her first marriage. She meets someone new, they get married. What are the implications on her estate planning? What types of things does she have to consider? And maybe I'll start with dependency. So let's start with her. So she has a husband, a new husband, and she also has 2 children from her first marriage who are minors. So let's look at the list of who is a dependent family member under Alberta law. Let's start with spouse. She has a spouse. She is obligated by law to provide for him. Next, does she have minor children? You bet she does. She has 2 kids from her previous marriage. She has a legal obligation to provide for her. Now, here's where her will is going to be a lot different than it used to be. Her old will used to say, I give everything to my husband. Right. Failing my husband, I give everything to my kids. That's a lot like the will that I have that I described earlier for the listeners. So if she was to say in her new will, I give everything to my husband, now we have a problem. Yeah. That man is not the father of those children. Right. He is not the father of her kids from her previous marriage. And for that reason, she is absolutely not fulfilling her obligations to provide for her children because she's giving all of her wealth to her new husband. Now, I hear this all the time. I heard it yesterday in a meeting with clients. That new husband says, I know they're not my kids, but I love them like my own. They came, and I don't want to be cynical. I really say this sincerely, right? They came into my life. I didn't have kids, but I married this woman who has these 2 beautiful kids. They've become my own. I did not adopt them. We'll get into that maybe a little later. But, whenever they're with us in our house, I treat them like my own. I give everything to them. I consider them as my kids. So that wife is saying, well, I should just give all my wealth to him because he's going to take care of them because he's such a great stepdad. And I have to break the news to her, you're not fulfilling your legal obligations. I know morally that's maybe the way it'll play out. And I really pray that it does, if that's the will she writes. But that will very much offends her legal obligation. She's got to give something to her kids because he has no obligation to provide for them. He might change his mind later, right? Mm-hmm. The father of those children, their biological dad, might not allow those kids to see him anymore. And as much as he tries to support them, he can't. So, it's important to realize that there is sort of a cold side to this. And she has to essentially, and this is where it gets complicated, she has to make sure that she provides support in both directions. She gives something to her husband and something to her children from her first marriage. Now, note, that husband probably has wealth of his own. So how much he receives from her is questionable. And that's something that we very much fully explore in the estate planning sphere. Right here across in this office, the questions I'd be putting to her is, okay, well, what does he own? What does his wealth look like? What does your household look like? Who pays for bills? She'll say, oh, he pays for everything. In fact, he's very, very wealthy. I don't, if anything, I depend on him. Okay, that's interesting. Maybe your obligation to him is very little and you should give everything to your kids, right? So I guess what I'm giving the listeners here is a snapshot as to how to balance between giving to a second spouse and to dependent children. Oftentimes you're leaning more on giving to dependent children because they have little and they depend on you quite literally, whereas the second spouse might have assets of his own and he doesn't depend so much on the person who's writing the will. So it's tricky. And in writing wills for blended families like this, we often dig right into what does everyone's bottom lines look like? What does everyone's net worth? And what do expenses look like in the household?
Yeah. Just as I'm listening to you, I'm thinking how complicated the situation can be because let's say that the wife passes away. She leaves 2 young kids. She has an ex-husband. She's got this new husband, who gets custody of the kids if they're still minors? Like her former, like their father, or the step parent?
Yeah, her chosen. Yeah, does her choice of guardian trump the biological parenthood? Right. In most cases, to answer the question directly, it would be the father. The biological father remains is now the sole guardian of the children, and now assumes full custody of these children. That is the usual rule, right. And that's where the law starts. But not uncommon that these kids are very connected to their step parent, and would prefer sometimes to live with their step parent as opposed to their surviving biological parent. This is a very thorny family law issue that family law lawyers do have to tackle from time to time. Not my area, but from what I've seen, and it's my understanding that as a child gets older, in particular approaches the age of 12, 13, 14 plus, their legal voice becomes stronger. True, it's not the real deal age of majority, but as a 14-year-old, they can say to a judge, I don't want to live with my dad. I know he's my dad biologically, but my stepdad is really my person, and that's best for me. And judges listen very carefully and make decisions based on that teenager's voice. Yeah,
well, very complicated or potentially complicated area of law. What about let's say that the wife married her second husband, had children from a previous marriage. So it's the Brady Bunch scenario. How does that complicate things, or how does that change things, if at all?
Sure. So let's go back to the earlier scenario where the wife brings in children from her first marriage, but she marries, so to speak, a single man who has no children of his own. Mm-hmm. Her will is complicated, right? Because she is trying to divide her wealth between her dependent husband and her children from her previous marriage. His will is super simple, right? He has one dependent, her.
Yeah.
Right. And it's not uncommon that he says, yeah, give it to her because I love those kids too. And she'll send it down to those kids. And heck, if we die me and my wife die together in a car accident, give it to those kids because those step kids are like my kids. So I guess bottom line is his will is quite straightforward because his legal dependency is only really going in one direction, his wife.
Right.
And note, I guess footnote to that is he's not obligated to take care of those children. As the stepfather, he is not obligated to take care of those children in this scenario, especially since he did not adopt them in this scenario.
Okay.
All right, but change the facts. That gentleman also has kids from a first marriage, as you referred to it, dating yourself here, Gary, the Brady Bunch scenario.
The Brady Bunch, yeah.
And I'll join you on it. I know it well. Yeah. We're in the same book.
It's a classic.
Okay, so he has kids from his first marriage, and just to really add the highest level of complexity, those kids are also minors.
Right.
So it's a second marriage. He's got a 5-year-old and a 9-year-old. She's got a 10-year-old and a 12-year-old, both from previous marriages. Well, it's now a multiplicity of the exact same situation. He now owes an obligation to provide for his wife, but also has that obligation to provide for his kids. So it would not be wise for him to simply write a will that says, I give everything to my wife because she's my new everything. And she'll do right by my children. I wouldn't hang my hat on that for the same reason I mentioned earlier for him. Yes. So he's also now stretched in two directions. Now, I don't want to be puzzling for your listeners. I've certainly spotted some issues, but I'm happy to jump into some possible solutions here. At a very, very high level. And I absolutely, this is not legal advice and this is not one size fits all. But in that situation, what I often tell clients is, okay, dependency is a legal term. Let's move away from dependency. We can appreciate there's legal dependency, appreciate something, we need to service this issue, but that's not practical. That's not how normal people talk, right? So let's talk about normal people. So that man passes away. He's got kids from a first marriage and his wife. Let's make sure that people have a place to live. All right, well, his kids are probably going to go live with their mom.
Mm-hmm.
Okay. So just mix things up. Let's say the house that he lives in with his second wife, is in his name alone. Might make a lot of sense that he provide housing for his wife. So maybe that house is something that stayed with the wife.
Okay.
Now, maybe they own it in joint names anyway, but let's just say the house is in his name. So that's one thing to consider. Where is everyone living? Again, the kids are with their mom. They have a roof. His wife might not have a roof because the house might be in his name. So let's look at the house. Another thing we try to look at are ESPs, education savings plans. Let's make sure those plans stay alive and stay for the benefit of his kids. RRSPs, right? Registered retirement savings plans, highly tax efficient, as all your listeners should know, highly tax efficient to give that to your spouse. So I often would encourage him to give RRSP to spouse. Now, depending on the family, we might not be down to a lot left here. And if we're seeing a shortfall, so to speak, if he's feeling an obligation to provide more for his kids, this is where we look at insurance products as a means to infuse cash into that man's estate so that he can provide for his kids while keeping a house over his wife's head.
Okay, perfect. Just want to touch on a same-sex scenario. Can the family members of either same-sex individuals challenge the will if they're opposed to the relationship?
Mm-hmm. So if I understand it right, so a person has passed away.
Yeah.
And they're in a relationship, maybe a married or common law relationship with someone of the same sex.
Right.
Okay. And that surviving partner, the question is, can that surviving partner challenge a will? That, say, for example, says that gentleman gave everything to his kids from a previous relationship, but he left this partner who might have a seat at the table. Does that sound about right?
Right. Okay. Or alternatively, let's say that you have same-sex marriage, one spouse passes away, leaves everything to the surviving spouse. Can the family member of the deceased challenge the will if they were opposed to the relationship?
Okay, understood. The short answer is a yes, only in that the law by definition, right, in this society is open to anybody, right? If anyone wants to make a claim in court regarding a commercial issue, a contract issue, a family issue, a state issue, the court is here to listen. That's how the society we live in. The reality, though, is not everyone has standing to do such a thing, right? So if this person passes away, let's say he's in a same-sex relationship and he gives everything to his lifelong partner, and he has these family members that want to challenge this will he wrote, they're going to have to really it's an uphill battle. We'll put it that way, for them to try to show that this man was mentally incapable. So there was an incapacity, a mental incapacity, an inability to write a will. He was under an undue influence, presumably by the partner, to have a will that all goes to that other person. Okay. Those are the common grounds of challenges that his family would have to embark on. And I guess, this is somewhat editorializing the matter, opinion speaking. That is a very uphill battle. I mean, let's just for the sake of facts, just to prove the point, let's say this man was in this relationship with his partner for 25 years. Maybe they didn't walk down the aisle and sign the certificate. They were common law, but they were partners for 25 years. Why wouldn't that man give everything to his partner of 25 years? What man or woman or individual in their right mind wouldn't give everything to their partner of that duration? So that really shows how hard it would be for the family to make that challenge. But that's what the court is for. Certainly available for a challenge, even an uphill one like that.
Okay. All right. Well, let's get into a different scenario again. This time, let's say, and this is probably pretty common. Let's say that the parents own a cottage, and maybe they even inherited the cottage from their parents, but and they have, say, 4 kids. The kids grew up spending time at the cottage in the summertime, on weekends, school holidays, whatnot. And then one of the parents passes away, or both of the parents pass away. what are some of the complications that could come into play? Like like, can the parents leave the will or the cottage rather to all the kids? And if they do that, what are the issues? Can you maybe speak to that?
You bet. So let's set up a few that's a few details, right, to the narrative here. So let's say at the time of passing, the cottage was owned in mom's name. So let's say mom was the second to die. Dad died many years ago.
Yeah.
So at the time of passing, it's in the matriarch's name. She left a will that's, simple will that says, I divide my estate equally among my four children. Doesn't say a lick about the cottage. And that's okay. Because in her heart, she just wants her wealth divided equally among her four kids whom she loves equally. Right? And I don't want to fault that this fictitious person for writing a simple will, but that's commonly our scenario. So a will that says divide four ways, and now we have a cottage. Now, obviously that divide four-way formula works for cash. It's not rocket science. You just punch that number into the calculator, divide by four, and then you figure out what everyone's share is going to be. Yep. But you're not going to, you're not exactly going to saw this building in four ways, right? So common ways to respect this will is to, the executor would register the property into four shares. So there's right on the title, you'll see an undivided 1/4 interest to each of Bobby, Clara, Jimmy, and Sue. So here we go. 4 people on the title. And that is respecting the will, and an executor can absolutely do that. Many families do this every day in Canada as a means to distribute family property and keep it in the family, so to speak. Okay. Certainly, I'm sure all the listeners know where this is going, right? 4 owners, 4 people to jockey for the best, for our very few nice warm weekends that we have in Canada.
Yeah.
4 people to bicker about who's going to pay for the dock repair, who left a mess when they left over May long weekend, who's going to pay for the roof. I can go on all day. This is co-ownership. So when we have a will that does not say who gets it, for lack of a better term, we're basically putting our kids in a situation of co-ownership. Now, is that awful? Not necessarily. There are many families that co-own properties and make it work. But we're impressing on our kids that they're going to try. And, I guess my takeaway there is if we have an estate where we're going into co-ownership, let's have those kids agree on paper as to what co-ownership looks like. And this is something that many estate planning lawyers, real estate lawyers, this is a tool we have off the shelf. Let's, we tailor it a little bit, but let's come up with rules. And among those rules is who pays for what, how do we decide who gets the good long weekends? If someone wants out, what are the terms, right? Like people use a term, a right of first refusal or a shotgun clause. So if someone wants out, here's how they sell their share to the others, right? But note, this means that the 4 kids have to take it upon themselves to go into that co-ownership agreement after the death of mom. So that's a very end of pipe solution.
Yeah.
I guess if you want to be a little bit more proactive, let's say mom's still alive, she sees trouble coming. She sees that this is not going to go well. She's got the 4 kids. She wants to honor them 4 ways, but equally, but this property is a bit of an oddball. What does she do? Well, a few things. She could say right in her will, and this is not ideal, or it's not the first place I go to, but maybe there's 1 kid who should get it, simply put, right? Maybe 3 of them all live in Ontario or Quebec, and there's just the one that's here in Alberta, and it makes a ton of sense. This should go to Sue. Okay, so be it. But if she wants equality, then we have to make it very clear in the will. Property goes to Sue, the other 3 get cash, equivalent sums of cash. Well, now we really have to dig into her financials and make sure that she has the money to support such a thing. And then how much money do the others get? Well, we want to set it out in the will. The property shall be valued by maybe 2 members of an accredited appraisal institute. So we have an objective sum as to what that property is worth, and then the others get that sum of cash. So that's one way to deal with it. On occasion, we see something called a cabin trust. So we essentially put right into the will the co-ownership terms. Now, careful. I see a lot of literature out there making the cabin trust seem like the best thing since sliced bread. In my experience, It has its limits. What we're essentially looking at is a big 2, 3, 4, sky's the limit page section in the will that says the property shall remain in the estate. It shall be managed by this child, and he or she shall offer to all 4 children equal opportunity to use the cabin under these XYZ rules. I think that kind of kicks the can down the road. That still becomes a problem later, but it's an attempt to make it work. I think the one failure I see there is when we have a cabin trust in a will, we want to make sure that there is money set aside to service the cabin. What good is a cabin trust if it's not clear as to who pays for the roof repair or who pays for the dock? So it's common for a cabin trust arrangement in a will to also set aside a sum of money. But again, that money is going to go dry at some point. So I guess my general view on a cabin trust is it can work, but for a limited period of time. I tell families who really want a cabin trust in their will is let's structure this to run for 5 years. Then after 5 years or so, the cabin trust detonates, it blows up, and then we have a distribution at that time because we can't do this in perpetuity.
Right. That's interesting. To me, it just kind of highlights how important it is to do estate planning. Again, as you gather more assets, and especially assets like a business or a cottage or a vacation property, you got to be thinking, how do you want to exit that or distribute that asset? And a lot of times you need agreement among your adult children. Okay, John, I just want to kind of, speaking of a business, let's say you have a business owner, sole shareholder, and he's got 5 employees, and the business owner passes away. What are the implications, number one, for his business, and number 2, for the employees if there's no will?
Okay, so if there's no will, which is complicated in and of itself, but thankfully in the scenario you put to us here, he's the sole shareholder, and there's 5 employees. So business aside, this person's estate is it goes through a process, referred to generally as intestacy. So I guess we have to ask ourselves, okay, is there a will? No. And then we have to look at the standard rules and the default rules in Alberta. Who gets to administer this estate and who is the beneficiary of this estate? So let's keep it simple. Let's say he's married just the one time, traditional family unit. Yeah. So like many of the listeners probably know, the beneficiary of his estate is his spouse, and his spouse has the authority to administer that estate if he or she gets a grant of administration from the court. So bottom line is that person's partner will go get some paperwork, often referred to as grant of administration. People nickname it as probate. In the province of Alberta, that's taking a couple of months now. And once she or he gets that document, they can basically transfer all those shares to him or herself and continue running that company as if it was his or her company. Okay. So the horizon is bright. It's going to be okay. But until we get that grant of administration, until legal authority is confirmed by the court, because we don't have a will, my heart goes out to the employees, to the accounts payable, the accounts receivable, the business that needs to keep its lights on and customers to serve. In situations like that, and I've seen it before, a business can be paralyzed. Payroll can stop because the only person who could sign those checks for the company is now dead. And in the absence of a will, which could speed things up a little faster, we can be in a little bit of trouble here. Sometimes there's a co-signer on the business account that might get things through a little while, but I guess not to scare the listeners, we can expect that company to be paralyzed for a couple of months.
Right. So the employees could be put in a very detrimental situation in a situation like that. So, okay. And then just one last scenario. Let's say that you've got 3 shareholders. They're lifelong friends. Let's say that nobody's passing away in this situation, but what legal documents or what strategy should the 3 shareholders follow in this situation?
Yeah, the best practice here, and I'm hoping all the listeners are saying this all at the same time. Everyone say it at the same time. The document you need to get is the unanimous shareholder agreement,
okay.
USA. And I know everyone said it before I said it because they're diligent listeners of the show. Everyone said USA at the same time, a unanimous shareholders agreement. You know, a nickname or a common way to refer to this document is like your prenup. It's your prenup for your company, right? If your company was a marriage, this is your prenup. This is your agreement among the shareholders, right? Like the married couple. This is the agreement that says, if we want to go our separate ways, if one of us does not want to be in this business, this document lays out how we exit that, how that shareholder exits, how their shares are sold to the other shareholders so that this business is not disturbed and the investor gets his or her money back, so to speak. Yeah. A USA, unanimous shareholder agreement, often, I know you didn't ask this, but it also considers death. So what if the three of us are still in business together, no one wants to exit it, but one of our partners gets hit by a truck? Okay, how do we keep this business going? So what the USA will often say is, okay, if there's a sudden death of one of the shareholders, one of the main partners, his or her shares are automatically sold to the others, right? What we're doing here is we're preventing the shares of the deceased shareholder from going to his or her spouse, right? So let's say in the absence of a shareholder agreement, this person passes away and they leave a surviving husband. And that will says, I give everything to my husband. Well, guess what? He is now a shareholder in the company. He might know very little about the company. Right? Yeah. This is his wife's company. Yeah. And she's very successful with her partners, but he's a supporter. He is not part of this. So in the absence of a unanimous shareholder agreement, he is suddenly thrust into a partnership with these three people whom he knows very well, but he knows nothing about this business. Now we have trouble and now they're bickering. It could be an issue. So what a unanimous shareholder agreement will say is, upon her passing, she's the shareholder, her shares are sold to her partners. He is in a position as executor to collect the sell proceeds. And that way the company can move on without him. Okay. Right. And this is a reminder, and I'm sure a lot of the listeners know this one, is in order to make that work, obviously the USA is an important document, but we need to think practically, where's the money going to come from? Right. If those shares are going to be now bought out magically, where's the cash? What's the cash flow look like in this company? Is there cash in the register? What's your rainy day fund look like? How liquid and solvent are the other shareholders such that they can pay him out in the first place? So this sometimes leads to an insurance solution. And I know I'm not an insurance guy. This is key person insurance, key man insurance, key shareholder insurance to make sure that there's cash to make this whole plan work.
Mm-hmm. Okay. You know what, Jonathan, we're going to have to leave it there because we're coming up to almost an hour. So I just wanted to thank you again for being our guest and helping us to understand these special situations in estate planning. Your knowledge and your insight are very much appreciated. Jonathan, how can our audience get in touch with you?
Sure thing. I think probably the easiest way to find us is through our website. We are Underwood Gilholme Estate Lawyers, and our website is willsandestates.ca. Willsandestates.ca.
Okay, easy. I want to thank our sponsor once again, Customplan Financial Advisors. Customplan Financial Advisors is an award-winning MGA providing exceptional support and resources to the independent financial advisor. Please visit their website at customplanfinancial.com. This podcast is available on YouTube, Spotify, and at financialpodcast.ca. To be notified directly when new podcasts are available, please subscribe by visiting financialpodcast.ca. If you have an idea or a topic for a podcast or know of someone who would make a great guest, please send me an email to info@financialpodcast.ca. We'd also love to receive your feedback. Thank you again, Jonathan. You're a great guest. And to everyone else, have a fabulous day.
The views expressed here are those of the participants and not those of Customplan Financial Advisors, Inc., its affiliates, or subsidiaries. This is not intended to serve as a complete analysis of every material fact regarding any company, industry, or security. This presentation may contain forward-looking statements. Investors are cautioned not to place undue reliance on such statements, as actual results could vary. This site and podcasts are for general information purposes only and does not constitute investment advice and is not intended as an endorsement of any specific investment product or service. Individual investors should consult with an investment professional about their personal situation. Past performance is not indicative of future results. If you are unsure about what is the best course of action for you in your financial planning, then we suggest you consult a fee-based independent financial advisor or get in touch with us to discuss your individual situation. Our phone number is 604-687-7773.